it amounted to disenfranchisement of the voters, if votes were not considered, the declaration of the winner. Then down there it says, consequently, the disenfranchisement of those voters substantially affected the outcome of the election, since the results declared in the contained in the return form indicated a much lower margin of 4,000. Then Muhindo Rehema, my lord. Muhindo Rehema versus Wilfred Kiza, 90. Yeah, in volume 3, I think, my lord. Page, the first authority on page 3. Volume 3, yes. The holding is at page 890, my lord. There, my lord, 13,426 had not been considered. That first paragraph on top, my lord. And the lordship said that was significant to affect the result of the election in substantial manner. Now, let me also say some of these legal points, my lord. The first one, when we are determining substantiality, my lord, the number of polling stations that the winning candidate has won vis-a-vis those of the losing candidate is irrelevant. As you saw, my lord, from the theory of the first respondent, he attempted to tell us that, look, I have won in so many. I would have won in those others. Before I get to that, the number of polling stations that you have won is irrelevant. My lord, I take you back to Mbaju Jackson at page 501. This is the second volume. Mbaju Jackson versus Temple Video Mujungu, page 501 of volume 2 of our bundle of authorities. The actual holding is at 501. That case is the first one, in volume 2. Paragraph 92. The lordships in the court of appeal say it is true that neither the applicant nor the respondent number 2 won at any of the disputed polling stations. Just like here, we don't know who won. However, this cannot lead to the conclusion that such malpractices did not affect the result in a substantial manner. The election is won by the total number of votes cast and not by the number of polling stations at which the candidate wins. So that issue should be out of the way. You should not disturb your analysis, my lord. Secondly, my lord, the other point I wanted to emphasize on this issue as I walk away from it, it is irrelevant. It is theorization for the first respondent to say that because I won in the majority of the polling stations, I would have won even in those polling stations. And therefore, because he's saying that to say, my lord, that therefore the election was not or could not have been affected substantially. That theorization, my lord, when he came here in his answer and examination and began talking about trajectories, patterns, and those kinds of things, my lord, I'm saying that is without legal basis. For you to say, my lord, that because I won there, I could have won there, that guesswork, as I called it, my lord, as a reason for saying that the election could not be affected substantially is without legal basis. Adding the number of votes and subdividing, as Mr. Mbabas took my class through, is without legal basis. It is guesswork. And my lord, of course, it is not lawful that courts will not act on guesswork. They act on real evidence. For that, my lord, I've given you the decision of Okare versus R. In our third volume, I think. Yes, our third volume. Okare versus R. The page where the holding is 898. Okare versus R is starts at 896, but the holding is at 898. There, my Lord, the court was simply saying that courts do not act on fanciful theories. They act on real evidence. The reason, my Lord, from the reading of the answer to the petition, the reading of the affidavit, my Lord, if you followed the cross-examination of Mr. Mbabazi, the theory was simple from the first respondent. In the second, third group.
My Lord, just forgot to follow. We don't have 898, the one being corrected.
You have
Our copy has 891. From there it goes to 916.
That's it. Listen, just say it. It is there. The case is there. That one. Right. That case. I think the pages were misfired. Or maybe you have caused the violence. 898. My Lord, the point I was making before I was helping Mr. Sabganda is this: that this theory that the first respondent put in his answer and pursued in cross-examination, okay, was tending to show, the theory was to show that because of the patterns that he referred to, trajectories, guesswork, okay, he was saying that I would have won in those polling stations. But that's not where he stops, my Lord. He's saying because of that he won in majority, I would have won in the 14, therefore the election would not be affected substantially. That's where he leads to. And my point, my Lord, that I'm making with this decision is that theorization basis and cannot be a reason for saying that the election would not be affected in a substantial manner. Let me also make this third point, my Lord, again as I walk away from this issue. What is at stake, my Lord, if we first put the rights correspondent? Let's also think about the 16,640 voters who were disenfranchised. These people went to vote. We don't know how many went. We don't know how many turned up. But we know that people turned up to vote at these polling stations. But their results are nowhere to be seen, my Lord. They are not in the tally sheet. They were disenfranchised. My Lord, can we say, therefore, that their votes don't count, that their votes carry less weight, that their votes are irrelevant? My Lord, their lordships in the court of appeal have said no. Please don't treat them like that. This is the case of Mbagadi Frederick Nkai versus Dr. Frank Yafiso. My Lord, that is at page 901, but the holding is at page 926. This is holding now. The actual holding, my Lord, is on 926. Yes, but the authority starts at 901. My Lord, there are saying, please also look at the 16. Don't only look at the petitioner and the respondent who wants to be in parliament. There's something else at stake. It is the 16,640 voters whose electoral choice was not taken care of. And my Lord, disenfranchisement of these voters happened far from Mr. Muizi's cross-examination of they voted so they were not disenfranchised. No. Disenfranchisement does not only mean being stopped from voting. It goes all the way. When I vote, and my vote is not counted or not tallied or given less weight, I am disenfranchised my vote. That is Apollo Kantinti. I will go back that decision. I don't want to take it back and forth. But what I'm saying is that decision, that disenfranchisement also goes as far as that. When you go to that decision, you see the various highlighted parts. Now, my lord, disenfranchisement is fatal. Disenfranchisement of a number as great as this, nearly double than the margin, nearly double the margin between the first responder and the petitioner, is fatal. The election cannot be upheld by one. Kantinti, my lord, is one of them. The other one I have is Atan Kokia. I think I've also referred to it. My lord, Kantinti have to that effect. My lord, we have highlighted that particular part. I don't have to go back. You cannot give the 16,640 any less weight. Now, my lord, with that, on this point, I invite you to find an hold first that there was non-compliance with the provisions of the Parliamentary Elections Act relating to elections, and that non-compliance, my lord, affected the result of the election in the substantial. I now, my lord, I don't know if, yeah, done. I go to the next issue. The next issue is whether there was an illegal practice or any other offense under the PEA committed by the first respondent in connection with the election, personally or with his knowledge and consent. My lord, under this ground of setting aside the election, we pleaded for illegal practices or offenses. I'll begin with bribery. Bribery, your lordship, is prohibited under section 87, subsection 1 of the PEA. And my lord, from a long line of cases up the apex court, they have interpreted that section again and again and crystallized three key ingredients of that illegal practice. For me to succeed on bribery, my lord, I should show you three things. Number one, that a gift was given to a voter. Two, that the gift was given by the candidate or his agent. Three, that the gift was given to induce the person to vote for a candidate. Once I prove that, my lord, I have proved the illegal practice of bribery. My lord, that is stated, what I've just said is stated in the case of Gaddafi Nasur versus Sekabila Dennis, quoting the decision of Kizza Besigye versus Museveni. Those ingredients that I have to prove, my lord, the cases are in third volume. It starts at 963, but the actual holding is at 987. The actual holding is at 987, but the authority starts at 963. My lord, I'll go through the evidence of each incident of bribery. And I'll begin with that of Maumbe Jodori. I'll go through one by one, my lord, evaluate the evidence, and then make a general comment on the law. I'll not speak about the law in each incident. I'll speak about the law generally. But I have first take you through the evidence for each incident. Now, I'll begin with Maumbe Jodori. This gentleman, on the 9th of April 2025, saw an affidavit for us, a petition. My lord, I think in the examination you are able to note the numbers, the pages where that affidavit is. But for abundance of caution, my Lord, is at page 1276 to 1278. In that evidence, my Lord, this gentleman stated that he is a registered voter at Clinton Junior School KIM polling station. My Lord, we gave that voter's roll as part of our evidence. On election day, he says that he met a man called Ben NALUKOOLA at Omar's place near a shrine under a jackfruit tree near a place called Zion Park. That place, my Lord, is found in Chiganda zone in Kawempe North constituency, not very far away from where the polling station is. He said that when he got there, he found Ben Mukasa giving money to people, and he gave him 5,000 shillings and asked him to vote for the first respondent. My Lord, this witness came to the stand and was extensively cross-examining his affidavit, and he remained firm that he was given 5,000 shillings by Ben Mukasa. Ben Mukasa also gave an affidavit. I said, my Lord, I refer to it without prejudice. He gave an affidavit where in paragraphs, my Lord, if you could note them, 6, 7, 8, 9, 14, and 15, he made repetitive bare denials of having given this witness a bribe. He simply says, I did not see. Bare denials, my Lord. He actually says to his face that I know these allegations are not correct because Maumbe has said in the second affidavit that they are not correct. Of course, thankfully, my Lord, that second affidavit is now out of the way. For Chamber Nathan Mwangs, the second incident, again, the registered voter at Clinton Junior School, KIM, we have given the voters roll, my Lord. He says that day of the election, he went to this parking lot and found Nachove and Ben Mukasa. Nachove gave him 10,000 shillings. Again, my Lord, the witness was cross-examined extensively, and rather than impeach, what was taken from that cross-examination, what I noted, is rather than impeach the fact that Nachove gave 10,000 shillings to Chamber, my learned friend who was cross-examining was only asking what the witness had done for Nachove to receive the 10,000 shillings. So the fact of receipt of the 10,000 shillings was not impeached. What the lawyer was trying to get around about was what was it for. And all this was towards the day of the election. The witness said, I have no relationship with Nachove or Ben Mukasa, and there would never have been any other reason to give me the 10,000 apart from voting for the first respondent. Nachove saw an affidavit, my Lord. I'm referring it without prejudice. Nachove made only bare denials. I did not use that man money. But what is striking are two things from her affidavit, my Lord, if when you retire, you look at it. Two things lavishly strike from that affidavit. The first one is that Nachove does not deny in her affidavit knowing Chamber Nathan Mwangs. She doesn't say so in her affidavit. She only says, and I quote, that she does not know Chamber Nathan Mwangs pertaining to the issues of Kawempe North by-election. So she doesn't say I don't know him. She says I don't know him with regard to issues of Kawempe North by-election. Something else striking from her affidavit at all. She does not deny being an agent, the first responder. Others try to deny it generally, but this one doesn't deny it at all. My Lord, I need to highlight in these two instances, if I go to the next one, I need to highlight the evidence they gave in court here during the examination when they stated that they were approached by Ben Mukasa and told and coerced and intimidated and whatever they said Ben Mukasa and whoever he did it with did to them. I must note that for these two incidents, that evidence that they gave here in examination is critical, my Lord. Okay, how they were approached by Ben Mukasa again, that this evidence will disappear. That is a key highlight of those two incidents. On the third one, my Lord, at Pentecostal Church, Polling Center, Wanjala someone came to the stand. Wanjala Solomon came to the stand and said, I saw Ben Mukasantale give money to voters who included Geoffrey Wampuira. When he was at the stand, my lord, he demonstrated the distance between him and the veranda where Ben Mukasantale was giving the money for. And as you could see, my lord, it was a very short distance. Wanjala could see what he was going for. Something is striking from the affidavit of Ben Mukasantale with regard to this particular incident, my lord. In that affidavit, from paragraph 1 to the end, Ben Mukasantale does not deny that he was at that police station. No way does he say, I was not there. He only says, I did not leave because the presiding officer asked me to leave. Kind of literally saying, I left on my own. But he doesn't say, I was not there. Again, he says, he doesn't deny I wasn't there. He says, I am not aware of any complaint filed against me at this police station by Wanjala Solomon. That's what he says in something, but he does not say that Wanjala Solomon, you are lying, I was not at that police station. He doesn't say that. Now, with regard to those three incidents, there's something I want to highlight. Maumbe, Chemba, and Wanjala. Let me highlight this, my lord, with regard to those three incidents. All these three incidents, my lord, took place in Chiganda zone, LOC1. The polling station of Clinton Junior, KIM, and Pentecostal Church polling center are both within Chiganda zone, LOC1. So Ben Mukasantale was operating from Chiganda zone. And he does not say, by the way, in his affidavit, or even in Nacho, none of them says they were not in Chiganda zone on election day. None of them say so. In fact, from the evidence of Chamber Nathan Mount, my lord, this gentleman we're talking about, Ben Mukasantale, is a resident of this Chiganda zone. He's a leader of that zone. And he confirms that, my lord, in his own affidavit. So I thought I could highlight that bit, that this is all in Chiganda. So, now at Sekati, Navakoza Rita, bribery by Navakoza Rita and Sekati zone, one of the photos and everything. My lord, a witness Navukenya Margaret came and he said,
This first one was
the first one was Margaret.
by Mukasantale.
Yes, all those three incidents were bribery by Mukasantale. There were three incidents. To Navakoza, yes. Mukasantale, my lord, and Nacho in the first three, because Cheva was bribed by Nacho. So the first three instances is Ben Mukasa and Nacho. This one is Rita, Navakoza. And I'll say this very briefly, my lord. Our witness came here, Navukenya Margaret, and told us Navakoza Rita went to a registered voter called Chibuka Mary Diana and gave her 1, 2, 3, 4, 5 items. 2, she stated that this was during the election campaign. This was during the campaign for the by-election. When Rita came here, my lord, she did not deny. She did not deny that she was at the residence of Mary Chibuka Diana. She did not deny that she gave up the items. All she tried to do was to give a different version now of what she was doing, okay, during this campaign period. But at least she doesn't deny that during this campaign she was at the residence of Mary Chibuka Diana and that she gave up these items. That is paragraph 12 of affidavit in support of the first respondent's answer to the petition. When we cross-examined her, my lord, we were able to show that on this particular incident, when she went to Mary Chibuka Diana, she was wearing the party symbols of the political party of the first respondent. The photograph that he attached to try and give a different version of what she was doing, as we saw, my lord, towards the end of cross-examination, collapsed like a pack of cards, my lord. She started by saying, I took them with this phone. As later transpired, the phones were different. Some she had gotten from Facebook. Later expired, she didn't take them to the printer, the lawyer took them to the printer, blah, blah, blah. So that chain was completely destroyed. And so was her version of events as what happened during the campaign for the by-election. My Lord, also note, in all the incidents now, all of them, these people who are alleged to have committed the bribery, all of them are NUP leaders, National Unity Platform leaders. All of them. And they say so in their benefits. They are leaders and they are sponsored by the National Unity Platform. That is Rita and Chove and Ben Jari Mokasa. My Lord, which now brings me to the affidavit Secretary General of the NUP, David Lewis. There, my Lord. Yes, my Lord. I was evaluating evidence, then I go to the law. Which brings the affidavit of Davis Kubongoya, where he says in paragraph 5, 6, 7, 11, and 12, he says in all of those paragraphs, he indicates, one, that the NUP sponsored the first respondent. That's not in doubt. The first respondent agrees with it. Two, that party functionaries were active in the campaign and on the day of the election. He states, we will see, my Lord, that officials of the party were there. He actually says himself, I was there supervising the polling stations. Actually said, I am the one who took care of the welfare of the agents of the first respondent. Now, let me go to the law, my Lord, touching on all of those points that we're talking about. Now the law. First of all, my Lord, who is a registered voter? Because I have to prove, remember the first thing, my Lord, I need to prove that the person who was bribed is a registered voter. Who is a registered voter? Section 1 of the Parliamentary Elections Act defines who a registered voter is. How? As a person who appears on the National Voters Register. Once you appear there, whether you have a national ID, whether you have a voter slip, whether you have what, all of those things don't matter. Their lordships in the Court of Appeal have twice told us that the registered voter is the one who appears in the National Voters Register. My Lord, for that position, I have the case of Gadafi Nasu, which you have referred it earlier. My Lord, you will revert to it at some point. But the new one that I want to introduce, my Lord, is the case of Simon Muyanga Utaya. It is in our third volume, and the specific holding I want is at page 1016. 1016. Simon Muyanga Utaya. Am I pronouncing the name? Am I pronouncing the name?
My Lord, I'm married.
Simon Muyanga Utaya. Muyanja, he has corrected me, my Lord. The point I wanted to bring with that decision, your lordship, at that paragraph, at that page where I have taken you, is that for you to prove that you're a voter, you don't have to have a national ID. No. You don't have to have a voter slip, as I saw my colleagues representing my witnesses here. All that is irrelevant. Once you appear on the NPR, that is it. You are a voter. And my Lord, we have demonstrated that all people who were bribed in all these incidents were registered voters. Maumbe is, Chemba is, Wamkubira is, Chibukameli Diana is. These were the 4 people who were bribed. We have demonstrated that all of them are registered voters. Second, my Lord, what was the purpose of the bribe? That's the third ingredient I have to prove if I go back to the second one. My Lord, who gives money to a registered voter on the day of the election for anything else other than to induce them to vote for the first respondent? These people came here. They said, we don't have relationships with these people. We don't owe them money. They are not our relatives. So there is no other reason why they could have given us money apart from inducing us to vote for the first respondent. My Lord, for that, I don't want to waste too much of your time. I refer to the decision of Namboze at page 1064. You will see the decision there. It starts at 2023, but the actual holding is at 1064 and 1065. And I'll highlight it. And for now, on the part, my lord, of what could have been the purpose? What is the reason why you're giving away these things? For now, my lord, we submit that she gave out these items to a registered voter when the election was imminent. It was during campaign. Giving a gift to a voter during campaign is prohibited. These gifts were given during the official campaign period, which admitted on the stand and when the election was imminent. In Namboze, Bakalwa, the Supreme Court said, no, actually, no, my lord, that is Bada, Freddy Bada versus Professor Mianda Mutebi. Professor Mianda Mutebi, same situation. The election was 1 week away. Professor Mianda Mutebi gave a cow. Their lordships, the Supreme Court said that gift would not have been interpreted in any other way apart from a gift to a voter to use them to vote at the election. Now, let me go for a second ingredient now. Now, my lord, this illegal practice we are talking about, you have not seen me anywhere mention the first respondent himself. Okay? What now behooves me to prove and show to you, my lord, is that this illegal practice was committed with his knowledge and consent or approval. I have submitted, my lord, that all these people involved in this instance of bribery are NUP political leaders. NUP political leaders who, as I have said from the affidavit of Ruwongoya, actively participated in the campaign and election of the first respondent. They are all NUP political leaders who actively participated in the campaign and election of the first respondent. And Mr. Ruwongoya puts them in the field for that purpose. And the first respondent, my lord, says he is sponsored by his political party. That's fine. Now, my lord, my argument is, this first respondent here, Mr. NALUKOOLA, cannot on the one hand take benefit of the good activities of what his party did, and on the other run away from the illegal practices of what his party officials did. He cannot approbate and reprobate. I'll give you an example, my lord. In the affidavit of David Lewis, what does he say? He says, on election day, I moved around, supervising all polling stations and taking care of the welfare of the first respondents' agents. My lord, Ruwongoya was not the candidate. He is the Secretary General of the National Unity Platform. And he's saying that's what he did. My point is, the first respondent cannot take benefit of that. Okay? That's okay for my party to do. They took care of the welfare of my people. When it comes to bribery, you say, no, those are not my things, I don't know those people. He cannot approbate and reprobate. My lord, that's not a noble principle, but if it pleases you, I could refer you to the decision of the Supreme Court that has that principle at page Codro 1 of our bundle. Codro 1. The case name is Bison Okum and others versus you, Sierra Dallas. That's where the principle of approbating and reprobating comes. Let me also make this point, my lord, about these officials of the National Unity Platform. These are not non-influential political functionaries or leaders. No, these are councillors from their areas of operation, from their areas of the constituency. These are councillors who clearly were deployed by the party in the areas which they represent in the national leadership, where they knew the terrain very well, so they could carry out the practice of bribing people with utmost sophistication. These are not any lousy NUP people. No, these are leaders. We are not your day-to-day street boys. No. These are leaders, these are national leaders, all of whom are of the national unity. What has the court said about people like that and bribery? What has the court said? Lord, I refer to the decision of Yamukama James versus Keja William. That decision, my Lord, is in this third band. Is in our third day band of authorities. It starts at page 1121, but the actual holding is at page 1163, my Lord. I'm obliged.
Kodi dakika mbili uli ku Shalom Television Uganda Sebanyamapulisa ekyokola kya mukabito kwa ttendo Dr. nga kujja mu katono kumewo kusaa mukaaga n'eddakiika 2 agambye omusango guno kunyumira olina okugugoberera si buli kimu kyeboogera mu musango guno kijja kunyumira si byonna byeboogera nti bigenda kunyumira ekitegeera si byonna byeboogera
MRI TV eddoboozi ly'omuvubuka. Oli ku 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 MRI TV, eddoboozi ly'omuvubuka. Oli ku MRI TV, eddoboozi ly'omuvubuka. Oli ku MRI TV, eddoboozi ly'omuvubuka.